Hi, I'm Antonio Sordillo, a certified financial planning professional with Evergreen Financial Partners of Raymond James. And with me today, I have a very special guest, Mr. Brad Vezina, Director of Estate Planning at McLane Middleton Law Firm. Welcome, Brad.
Thanks, Antonio. Pleasure to be here.
So excited to have you. And estate planning, Brad, can be so off-putting to so many clients. So I wanted to ask you today why having an estate plan is such a vital part of a proper plan for clients.
An estate plan allows you to pass your assets and your wealth to your loved one or the family members in the least disruptive manner and in the most tax-efficient manner. We spend so much time accumulating wealth, building a financial safety net for our family members, but a lack of planning could substantially compromise that.
Brad, what documents are required as part of a proper estate plan?
Typically, an estate plan consists of a healthcare proxy and a durable power of attorney. Those are documents that you put together to anticipate becoming incapacitated. So if you can't make decisions for yourself, you need to name someone to make those decisions both financially and medically. You also need a last will, which is very common. Most people are familiar with a will. And the primary document in my mind, the flagship document, is a revocable trust. And that would be the final documents. I would say 4 documents: healthcare proxy, durable power of attorney, last will, and a revocable trust.
So Brad, you mentioned the revocable trust as a core document in an estate plan. We often hear revocable and irrevocable trusts, and I think it can be very confusing to people even in my profession often of what the two are. Could you just highlight the difference between the two for us?
Yeah, the differences pertain to the ability to change the document and the ability to control assets that you put into the trust. So a revocable trust is a trust that you can change at any time. You can put assets in, take assets out. You're deemed as the owner for tax purposes. An irrevocable trust is a trust that's typically it's designed for more tax or Medicaid or creditor protection, where you're putting assets into a trust. Usually you're naming someone other than you as the beneficiary, and you're relinquishing control, sometimes complete control. And oftentimes you see these in situations where you're making a gift into a trust. But I would say primarily for core estate planning, you're dealing with the revocable trust where you're not relinquishing any control. And again, that's more for probate avoidance and asset management if you have a family member or minor child who is too young to manage assets. The way I look at it is you got to layer it. You do the base planning, which is the healthcare proxy, durable power of attorney, will, and revocable trust. That's your core kit for estate planning. And then depending on the client situation, you may want to do an advanced layer and complement that suite of documents with an irrevocable trust. And there's life insurance trusts, call them ILITs, or spousal lifetime access trusts, there's SLATs. Those are all irrevocable trusts. So it's definitely the second step.
Well, Brad, thank you so much for all this information. And as you've touched upon a few different types of trusts beyond revocable and irrevocable, we could easily go down this wormhole and probably make a half dozen more videos on this topic alone.
Absolutely.
But thank you very much for scratching the surface with us. And I think just our conversation today highlights why having an estate planner that specializes in estate planning law is so important, because there are so many intricacies and details that cannot be overlooked for each individual client.
Absolutely, and happy to help.
Well, we appreciate your partnership, Brad, and look forward to speaking to you again soon.
All right, thank you.